Arbitration has been around for millennia. The leading modern authority on the history of arbitration and mediation, Derek Roebuck, tells us how arbitration was a preferred method of dispute resolution in Confucius's China and in Homer's Greece. Roebuck also tells us how arbitration even does something of an unexpected star turn in the excellently gossipy and readable, and it now appears surprisingly accurate, histories of the 5th century historian Herodotus. Herodotus records that in the late 8th century BC, Diocles set himself up as a private arbitrator in his Median village with some success. Indeed, he attained such a reputation for the justice of his decisions that when the Medes were looking for a king, they decided to appoint him. They made a good choice. He ruled for no less than 53 years and founded the Median Empire. Now, don't let this give any of you arbitrators royalist ideas above your station. The fact that in 1921, which is far more recent, the great English cricketer C.B. Fry was reputedly offered the crown of Albania does not mean that all successful cricketers should harbour regal ambitions. So should you arbitrators not hanker after an empire simply because of Diocles' good fortune? And equally, particularly as members of the Chartered Institute, I'm sure that none of you have to have your attention drawn to Derek Roebuck's reminder that it was partly taking bribes as an arbitrator which resulted in the great Lord Chancellor, essayist and scientist Francis Bacon being prosecuted, imprisoned, massively fined and stripped of his honours. But more to the point, and confining myself for the moment to the English experience, arbitration has been part of legally recognised dispute resolution in this country since before the memory of man runneth not to the contrary, which, as any land lawyer will tell you, means 1189. In his magnum opus on medieval dispute resolution, Derek Roebuck explains what a consistently significant part arbitration and mediation played in English dispute resolution in the period since, and indeed probably before, the Norman conquest in 1066. Often this was because of the slow, technical, and parochial attitude of the common law. Indeed, it might be said that arbitration performed a similar role to that of equity or chancery law in representing a route of avoiding the artificial rigours of the traditional common law approach to cases, with its serious delays, technicalities of pleadings, and strict limitations on the nature of the relief which could be granted. Like equity, arbitration could be more practical and informal, more concerned with a commercially just result than a strictly legal outcome. Indeed, the role of arbitration in medieval and Tudor times appears to have been similar in some ways to the role of mediation today. In the following centuries, arbitration can be seen as again marching with equity. Initially, as regards equity, the courts of chancery adopted an approach which depended very much on the particular Lord Chancellor's ideas of right and wrong. Hence the 17th century John Selden statement that equity varied with the length of the Lord Chancellor's foot. But by the late 17th century, the courts of chancery were starting to develop relatively strict rules, so that by the early 19th century, with the notoriously conservative Lord Chancellor Eldon, equity as administered in the courts of chancery had become relatively rigid in its rules. Similarly, having initially been pretty informal and independent of the courts, it appears that by the 18th century, arbitration had become more formal and bound by legal procedures and substantive law. And it's quite interesting to see how that arose. Parties to arbitrations needed the assistance of the courts to enforce their rights, in particular to enforce an arbitration agreement and to enforce any subsequent award. The courts were prepared to oblige, but for a price. And that price was judicial intervention and judicial oversight. And the judge's purpose was to ensure that arbitrators adopted legally defensible procedures and made awards which accorded with the parties' legal rights. The somewhat patronizing Big Brother approach of the courts towards arbitration was then set for the next 2 centuries or so. Indeed, it was reflected in the first comprehensive statute dealing with the topic in this country, the Arbitration Act 1889. Thus, in 1922, less than 100 years ago, no less a judicial authority than Lord Justice Scrutton, a rather more fierce muscle of his age, was able to say this in one Court of Appeal case. Arbitrators, he said, unless expressly otherwise authorized, have to apply the laws of England. When they are persons untrained in law, and especially when, as in this case, they allow persons trained in law to address them on legal points, there is every probability of their going wrong. And for that reason, Parliament has provided in the Arbitration Act that not only may they ask the courts for guidance and the solution of their legal problems in special cases, stated at their own instance, but that the courts may require them, even if unwilling, to state cases for the opinion of the court on the application of a party to the arbitration, if the court thinks it's proper. And he explained that this is done in order that the courts may ensure the proper administration of the law by inferior tribunals. I think he meant inferior in the technical sense. I certainly hope he did. In my view, to allow English citizens to agree to exclude this safeguard for the administration of the law is contrary to public policy. That attitude, I think, largely persisted when the Arbitration Act 1950, replacing the 1889 Act, came to be enacted. Indeed, the following rather evocative description of the judiciary's attitude to arbitrations is not a bad summary of the position until about 50 years ago. Carbonneau wrote as follows: "The relationship between arbitration and the courts had all the trappings of a Cinderella story or a Dickens novel. Arbitral tribunals were thought of as the stepchildren of the legal process, and it was believed that they should recognize their disabilities and lowly status and allow courts to supply the lawful conclusion to litigation." If I may build on the literary allusions made in that observation, it took nearly 30 years from the 1950 Act before arbitration, like Cinderella, could set off for the ball of arbitral independence and legal responsibility, and started to rival the importance of her ugly sister or big brother in the courts. With the Arbitration Act 1979, the legislative fairy godmother waved her magic wand. An admittedly limited notion of party autonomy and arbitral responsibility entered the picture. And with the much more comprehensive and radical Arbitration Act 1996, Parliament fitted the glass slipper of arbitral finality and party autonomy on arbitrators. In other words, the legal system in this country finally acknowledged that arbitrators should be allowed far more independence than they had previously been accorded. And unlike, some may say, the banking sector, such modern light-touch regulation is not merely what the market wanted, but nearly 20 years later, it is generally seen to be working well. The enormous change of attitude to arbitration in the legal and lawmaking establishment of this country over the past 50 years is attributable, no doubt, to a number of factors. But I detect 9 factors which either can be identified as clearly relevant or are invoked from time to time in order to explain. The first is the growth in demand for arbitration, particularly internationally. And that's a demand which this country should be particularly sensitive to in the light of its preeminence in the field of international business and financial and legal and other services. The second factor is the high professional standard which is and has for some decades been generally attained by arbitrators. The third factor is the fact that arbitrators can be selected for their expertise, whereas one takes pot luck with national judges. The fourth factor is distrust of national courts in the context of international disputes. Each party fears that the other party's national court will favour its own nationals, or may be unsatisfactory in some other way. Fifthly, there is the ease of enforceability of arbitration awards when compared with court orders. The New York Convention is probably the most successful international convention in terms of the extent of its international adoption. The sixth factor is speed. It's often claimed that arbitration is a quicker way of resolving disputes than litigation. The seventh factor is expense. It's frequently said that arbitration is less expensive, cheaper than litigation. Eighthly, arbitrations are confidential, whereas most court hearings, of course, take place publicly. The last factor is finality. Because of the difficulty of appealing or otherwise challenging an arbitration award, the award is very likely to be final, whereas, of course, court orders are easier to appeal. Now, I'm not sure about the extent to which all these reasons are valid, and I'm quite sure that some of them are not valid in many cases. Thus, I would take a lot of persuading that arbitration is normally cheaper than litigation, at least where lawyers are involved on both sides. And when compared with cases tried by judges, at least of the English and Welsh Commercial Court, Chancery Division and TCC, I would have thought that litigation could often easily be quicker than arbitration, and that the technical quality and experience of the tribunal would often match that of many arbitrators. And I hope and believe that at least the United Kingdom judiciary are respected not only for their expertise and probity, but also for their independence and international outlook and open-mindedness. And it's fair to say, having had the pleasure and experience of meeting judges from many other jurisdictions and reading their judgments, that I should not leave this topic without emphasising that I'm not intending to be parochial. I know the UK judiciary. I'm probably therefore biased about it, but at least know about it. I cannot speak with such confidence and authority about other judiciaries, but I have no doubt that there are many other judiciaries represented here today, from countries represented here today, which can make the same claims as can be made by the UK judiciary. Having said all that, there is no doubt that at least some of the 9 reasons would have considerable force in many circumstances. And we judges have to remember that the courts are unusual. They do represent a constitutional institution that has independent constitutional responsibilities, but they also represent a service. Our system, for instance, in England and Wales, is known as Her Majesty's Court and Tribunal Service, and it is a service. And therefore we have to bear in mind that if there's a demand for arbitration as a way of resolving disputes, then save to the extent that there's anything unlawful, unconstitutional or improper, or some other good reason to say no, that demand should be accommodated. It's consistent with a liberal economy, and it's consistent with the concept of personal autonomy. Obviously, there's no question of such a desire being accommodated if it involves anything unlawful. For instance, the criminal law must be enforced through the courts, and the court's duty to protect children's interests could not be delegated to an arbitration tribunal. So too, I think, the court would have power to step in and prevent breaches of natural justice or something akin thereto. The high quality of arbitrators is a tribute to the organisations which educate and train them and set the standards for them. That is something which the Chartered Institute has been doing literally, of course, for 100 years, and not merely in the UK. The Institute paints on an impressively broad international canvas. It's a point that was brought home to me when I attended your Centenary Conference in Hong Kong 3.5 months ago, and the international nature of arbitration in general, and the Chartered Institute's reach in particular, is emphasised by the contents of your programme for this conference, and the many different countries from which the participants come today, and from the fact that my friend and judicial colleague, Sundaresh Menon, is your patron. Bearing in mind how very busy he is, the fact that he is here today to address you and take part in this conference is a tribute both to the Chartered Institute and to him. In Hong Kong, I talked about the importance of arbitration to the rule of law. I noted that the role of arbitration in maintaining the rule of law was a feature which had been emphasised by the Chartered Institute's former president, Lyndon Macassey, in a speech he gave over 50 years ago. In that speech, He said, and I quote, "The case for independent arbitration is stronger than ever because the need for maintaining the rule of law was never more urgent." And such is the growth of international arbitration that you arbitrators do have a very important function in maintaining and indeed advancing the rule of law across the world. International courts are relatively few and far between, and they tend to have a limited function, and it is not very often a commercial law function. So when it comes to the rule of law internationally, particularly in the commercial field, arbitrations and arbitrators in many ways can be said to have a similar role to that of courts and judges domestically. That means that arbitrators, and indeed all those involved in international arbitration, have a real responsibility for carrying out and being seen to carry out their functions to a consistently high standard in terms of probity, efficiency, fairness, honesty, and lawfulness. And that in turn means that organizations responsible for training, educating, and validating arbitrators, and for promoting arbitration and promoting best practice in arbitration, have a duty which is greater than it ever has been. Preeminent, internationally renowned, and well-established and experienced organizations, such as, indeed perhaps above all, the Chartered Institute, therefore have a particularly heavy responsibility. The duties I've been discussing are all the greater in the light of investor-state dispute settlement clauses, on which the Chief Justice of Australia, Robert French, spoke so interestingly at the Hong Kong conference. Such clauses are, of course, routinely included in international trade agreements, such as the now well-established North American Free Trade Agreement, NAFTA, or the Transatlantic Trade and Investment Partnership, TTIP, and the Trans-Pacific Partnership Agreement, TTP, both of which are currently being controversially negotiated by the United States, in one case with many Eastern Asian countries, and in the other case with most European countries. The most significant rule of law concern to which they give rise is that they can apparently result in private arbitration tribunals having jurisdiction superior to that of national courts, even the highest national court of a signatory country. Thus, it would seem that such arbitral tribunals can require national courts to take or to refrain from taking certain steps, and to determine that some rulings of national courts are unlawful. Let me give two examples. An arbitral tribunal ordered an Ecuadorian court to suspend a judgment for $9 billion against the petroleum company Chevron in respect of a claim in environmental tort. And when the Ecuadorian court nonetheless formally entered the judgment on the record, the tribunal invited the Ecuadorian government to explain why it should not compensate Chevron for any loss suffered as a result of the court's refusal to stay the order. Another example, Eli Lilly has a pending arbitration claim against Canada for over $500 million. That claim is based on the proposition that the Canadian Supreme Court's decision in validating certain patents on the basis of well-established Canadian patent law violated Canada's obligation under NAFTA to afford what was called fair and equitable treatment to foreign investors. That matter is to be heard by an arbitral tribunal next year, and if they rule in favour of Eli Lilly, they will in effect have declared that a decision of the Canadian Supreme Court is unlawful. These cases, at least arguably, raised cause for concern on the constitutional front, as Robert French said. But for today's purposes, their relevance is that they demonstrate the financial and political importance of international arbitration, the vital role it can play in relation to the rule of law, and the shift which may be occurring in the balance of power between courts and arbitration. It can be said to show that arbitration in the 21st century has, at least in some significant respects, turned the tables on the courts. Lord Justice Scrutton's perception less than 100 years ago that the courts must ensure the proper administration of law by inferior arbitration tribunals has given way to the sight of arbitration tribunals purporting to require courts to apply the law as the arbitrators assess it, at least when it comes to international trade agreements. The duties which this development casts on all organizations concerned with promoting arbitration agreements and arbitration standards, and particularly the leading organization, are considerable. It seems to me that developing and promoting the London Principles of 2015 is just the sort of thing that the leading professional arbitration organization in the world should be doing. The principles are described as being, quote, necessary for an effective, efficient, and safe seat for the conduct of international commercial arbitration. And they set an appropriately but not unattainably high standard without being too prescriptive. Bearing in mind the identity of those who were involved with preparing these principles, it's scarcely surprising that they are very impressive, pretty comprehensive, and patently well thought out, and both clearly and concisely expressed. You will be discussing them later today, so I will refer to some of them briefly. The first principle concerns the state of the law of the seat, and it must respect the party's choice of arbitration, and therefore it must A, provide a proper framework for a fair and just arbitration process, and B, it must limit the court's intervention subject to supporting the arbitration process. The devil is, of course, as usual, in the detail, and it's a question of degree. How narrow are the limits, to use the word of the principle, of the court's power of interference? Any formula raises issues of opinion and emphasis. But I suppose that in light of the requirement that the framework is to enable fair and just resolution through the arbitral process, one useful guide might be that the court should be ready to interfere when the arbitration has for some reason ceased to be fair or just, but rarely should the court otherwise interfere or even contemplate interfering. The second principle is concerned with the judiciary, and it states that the judges of the seat should be independent, experienced, and respectful of the party's choice of arbitration. I suppose that it might be worth adding something about them being good judges as well. After all, none of the three specified qualities actually guarantee a high-quality judiciary. Maybe it's too obvious or too controversial to include such a stipulation. I also wonder whether it's worth adding something about an accessible and efficient court system. Delay and poor administration in the courts are, I would have thought, inimical to commercial arbitration, and I'm not sure that that is dealt with by either of the first two principles, which are entitled simply law and judiciary. The third principle is concerned with the legal profession, which must be both experienced and providing significant choice. As in relation to the judiciary, it can be said that neither of those adjectives cover competence or repute, and indeed there is no reference to the profession being independent. Again, these features may be self-evident or controversial, but I should add that I do not consider that it can be safely assumed that these concerns are assuaged by Principle 8, which is concerned with ethics. The fourth and final principle I want to comment on refers to a commitment to educate all those involved in arbitration in the character and autonomy of international commercial arbitration. Again, it may be an insensitive or impractical suggestion, but I do see force in the notion that there should be more than a mere commitment. Surely what one needs is action, not words, the concept of something along the lines of an implemented commitment. Having made these rather tentative comments in relation to the first four principles, I have nothing to add to the fifth to 10th principles: right of representation, accessibility and safety, facilities, ethics, enforceability and immunity. As I've said, the principles all seem admirable and attainable, and the whole document is just the sort of thing which the Chartered Institute should be promulgating. It accords with the Institute's responsibilities, particularly bearing in mind the role that international arbitration now plays in the rule of law. The fact that international arbitration, and indeed to some extent domestic arbitration, plays such a part in the rule of law can give rise to questions as well as responsibilities. The questions include the issue of confidentiality. It is, of course, a fundamental principle of justice and of the rule of law that all trials are held in public, and particularly in a common law system, it's an equally fundamental principle of justice and the rule of law that the judgment of the court is made publicly available. Of course, there are exceptions, but they must be fully justified, and any secrecy must be strictly necessary and kept to a strict minimum. But in order to ensure public confidence in the justice system and in the judges, the public need to see how and why we reach our conclusions. One of the big criticisms of the notorious Court of the Star Chamber in the 15th, 16th and 17th centuries was that all the evidence was taken in secret. And it's no coincidence that the Court of the Star Chamber was abolished in the same century as parliamentary elections, no taxation save through Parliament, habeas corpus, and judicial security of tenure, i.e., many of the fundamentals of the rule of law, became part of this country's constitutional settlement. Now, so long as one regards arbitration as a purely private contractual arrangement, considerations such as open justice are of little weight. But the international rule of law function and status, which international arbitration is starting to achieve, means that it's by no means so clear that arbitration can always properly be subject to a confidential process. Once arbitrations start to become disputes in which there is a public interest, even where that interest is indirect or contingent, then the argument that the public should know what is going on, what the arbitrator's decision is, and why and how it was arrived at, becomes stronger and harder to resist. And the fact that it's so difficult to appeal against arbitrators' awards is another reason why awards, at least if they're reasoned, should be published. The law, and particularly the common law, develops through the medium of judicial decisions. In the absence of a good number of cases on some topics passing through the common law courts, there is a grave danger of the law on those topics atrophying, failing to keep pace with social, commercial, and technological developments. And that's a particularly grave problem when the topics concerned are many aspects of commercial law, and when the problem occurs in the 21st century, when social, commercial, and technological changes are occurring at a far greater rate than ever before. One only has to think in this country of the enormous long-term beneficial changes made to the commercial common law by the decisions of the great Lord Mansfield in 18th century England to see how important it is that there is a body of law of reported cases and decisions which enables the law to develop. In these circumstances, particularly in the light of the high quality of most expert and experienced arbitrators, many of them thanks to this institute, it seems to me that very serious consideration should be given to regular and indeed almost automatic open arbitration in some cases and published awards. There has for some time, I'm glad to say, been a move towards publishing at least excerpts of international awards. Since 1976, this has been done, of course, in the annual commercial arbitration yearbooks. And there have even been some public hearings of arbitrations insofar as they relate to the international trade agreements to which I made reference. I suggest that it's no coincidence that it is in relation to such arbitrations that publicity is most advanced. The public interest in such arbitrations is self-evident in the light of the two examples I gave earlier, namely the Chevron Ecuador and the Eli Lilly Canada cases. Further, the strong public debate in and out of Congress in the United States in relation to the proposed TTIP and TTP agreements, and the public debate about the TTIP agreement in the UK demonstrate the general interest in and concern over such agreements more widely. As a final parting shot in relation to the responsibilities of arbitrators, may I refer to a problem which bedevils both arbitration and litigation, at least in this country, namely the thorny issue of costs. When I addressed the Chartered Institute a few months ago briefly on the opening of the Arthur Marriott Room, the very ill but very plucky Arthur Marriott spoke for 5 minutes in clear and ringing terms. And what he concentrated on was his concern over the high cost of commercial arbitration. As I say, the complaint is also one which applies to litigation. Interestingly, research I've seen suggests that the cost of the arbitrators and overheads is under 15% of the total cost of a typical commercial arbitration. So the principal problem, as of course is the case with litigation, lies with the charges of the lawyers to the parties. In court proceedings, at least in England and Wales, judges have a duty to ensure, as far as they can, the costs are kept to a level which is proportionate to the issues at stake. Such a role is, of course, easier in many ways for judges than it is for arbitrators, given the consensual nature of arbitration and given an arbitrator's desire for appointments to other arbitrations. However, I suggest that along with the other duties which come with the increasing rule of law role of international arbitrators is a duty not to let costs get out of hand and to ensure that any award of costs is proportionate both in outright quantum and in terms of the justifiability of the work for which it is sought. Such an attitude, I suggest, also ultimately reflects self-interest. If arbitration attracts a reputation for being over-expensive, arbitration will start to fall away, whereas if arbitration maintains a reputation for affordability, there will be more work for arbitrators and for all those involved in arbitration. The attraction of arbitration because the costs were less has, I've mentioned, long been said to be an advantage of arbitration over litigation, and therefore a reason to arbitrate rather than to litigate. Let me end where I began, namely by citing Derek Roebuck. This time I have in mind his story of John Wheathampstead, Abbot of St Albans, who in 1431 boasted that he had saved his house 1,000 marks by avoiding litigation with William Fleet of Rickmansworth and opting instead for arbitration. According to an apparently reliable website, not I think available to John Wheathampstead, the abbot saved his abbey the modern equivalent of around £400,000. Well, if Abbot Wheathampstead's 21st century equivalent comes to arbitrate before one or more members or fellows of the Institute, I hope that the costs are managed sufficiently well for him to be able to repeat the 15th century boast of his predecessor. Congratulations to the Institute on its centenary, and congratulations also on developing the principles. Thank you very much indeed.